Live. Good evening, students. I'm Rohit, and today we have to start with the oath. See, in the last class, we have completed the appointment, number of judges in the Supreme Court and High Court, and the qualification. And today we will start with the oath. Okay, so first we will discuss the basics. That is oath, tenure, then resignation, then transfer. After discussing all these things, we will start with the most important part in the judiciary because it is lately in news. You must have seen that a lot of cash was found inside a particular place. Okay, so because of this transfer of High Court judge and the removal is in the news. So we have to study even for that. So first we will start with the oath. Now remember, when it comes to the Supreme Court, in Supreme Court there is Chief Justice of India and then there is Judges of Supreme Court. The oath to the Chief Justice and the judges is administered by the President of India. Okay, so it doesn't matter whether it's the Chief Justice of India or the judges of Supreme Court. It is the President who administers oath to the Chief Justice and to the judge. Now it comes to High Court. See, in High Court we have Chief Justice and the remaining judges of the High Court. Now remember, the appointment to the judges of High Court is done by the President. But when it comes to the oath is administered by the governor. You should not be confused that they are appointed by the President. So by this logic, the President should administer oath to the judges of High Court. No. The appointment is done by the President, but the oath is administered by the governor of that state. So the Chief Justice and judges, they both are administered the oath by the governor. See, the role of governor in the judiciary is highly limited. Everything is done by the President except for this oath. Okay. See, when it comes to the appointment or when it comes to the removal, resignation, all these things are done by the President and not by the governor. Okay. In the Constitution, it was mentioned that the President, while appointing the judges of High Court, has to take consultation from the Chief Justice of India and the governor of the concerned state. This was according to the Constitution for the appointment of the High Court judges. But in reality, there is collegium system, and in collegium, there is no scope for the consultation from the governor. Okay. So the final answer is the oath to the Supreme Court judges is administered by the President and to the High Court judge is administered by the governor. Now, after oath, we will start with the tenure. That what is the term of office? Okay, so what is the term of office of governor and not of governor, of the Supreme Court and High Court judges? Now remember, there is no term of office for the Supreme Court and High Court judge. They do not hold office for 5 years or 6 years, 7 or 8 years. No, they hold office until they attain the age of retirement. That is 65 years. So, what is the tenure of Supreme Court? They do not have, they don't have any tenure. They hold office until they attain the age of 65 years. So, what we will write? That there is no term of office of Supreme Court. They hold office until they attain the age of 65 years. So it is clear that there is no term of office for the judges of Supreme Court. They are there till their retirement. Now for High Court, the same answer, but in place of 65, you should write 62 years. So the answer is for neither for the Supreme Court nor for the High Court, you will find any term of office. It is all about the retirement. They retire at the age of 65 and they retire at the age of 62. But one more thing, for High Court, you have to remember, this is an important point. And the importance is that earlier, the judges of High Court used to retire at the age of 60 and now they retire at the age of 62. So it means their retirement age has been increased by 2 years, 60 to 62. Now how this was done? This was done by an amendment to the Constitution. Now we have to remember the number of the amendment. So the amendment was 15th. The amendment was 15th Constitutional Amendment Act 1963. So by this amendment, the retirement age of judges of High Court was increased from 60 to 62, but there was no such amendment for the judges of Supreme Court. For them it is 65, but for them it was earlier 60 and now it is 62 years of age. So this was the term of office of the judges of Supreme Court and High Court. Now moving ahead, now we will discuss the salary. What about the salary of Supreme Court and High Court judge? Now remember, see, for this particular part is common for both. Remember, the salary, allowances, pension, leave and privileges. The salary, allowances, leave, pension, privileges, all these are determined by the Parliament by law. So Parliament by law has the authority to determine the salary, allowances, leave, pension and privilege for the judges of Supreme Court and High Court. So whether it's Supreme Court or High Court, the salary is determined by the Parliament and not by the state legislature. Okay, so all these for both Supreme Court and High Court are determined by the Parliament by law. Now what is the salary of judges of Supreme Court? So for Supreme Court, what we will see that the Chief Justice of India receives 2.80 lakh per month, and the judges of High Court, and the judges of Supreme Court, they receive 2.5 lakh per month. Now what about High Court? So the judges of High Court, when it comes to the Chief Justice of High Court, the Chief Justice of High Court receives 2.5 lakh per month. 2.5 lakh per month, and for the judges of High Court, they receive 2.25 lakh per month. Okay, so this is the salary for the judges of Supreme Court and High Court. But I don't think that these kind of questions are going to come in the examination, that how much they receive. What is more important, that who determines that how much they will receive, and the answer is Parliament. Whether it's for the Supreme Court or for the High Court, the answer is Parliament by law can determine the salary, allowances, leave, pension, privileges for both the Supreme Court and High Court judges. Now, apart from this, you must also remember that from where the salary comes. So, in case of Supreme Court, both salary and pension, they both come from Consolidated Fund of India. Consolidated Fund of India. Okay. So the salary is charged upon the Consolidated Fund of India, and same for the pension. But what about the judges of High Court? Now remember, here there is a difference. When it comes to the salary of the judges of High Court is charged upon the Consolidated Fund of the state. Consolidated Fund of the state. And when it comes to the pension, now this is important, the pension of the judges of High Court is charged upon the Consolidated Fund of India. Now this is the difference. The salary comes from the Consolidated Fund of State, whereas the pension comes from the Consolidated Fund of India in case of the judges of High Court. But for the Supreme Court, it's same. Consolidated Fund of India, whether it's pension or salary. Okay. So finally, we are done with the salary and pension of the judge of Supreme Court and High Court, who determines from where it comes and what it is. Now, after the salary, now we can start with the resignation of the judges of Supreme Court and High Court. Okay, so answer is simple. When it comes to the Supreme Court, the Chief Justice or a normal judge of the Supreme Court, they tendered the resignation to the President of India, because President was the authority who appointed them. So they will give their resignation to the President of India. And for the judges of High Court, so the Chief Justice of High Court and the judges of High Court, they also give their resignation to the President of India. As I said, that the role of governor is just to administer oath to the judges of High Court. When it comes to the appointment or removal or the resignation, everything is done by the President of India. Okay, so this is the resignation. And now, at present, it has gained importance because of the transfer of Yashwant Verma, the Delhi High Court judge, who has been transferred to the Allahabad High Court judge. So now the transfer is in news. So we must also understand that what is the transfer of High Court judge, under which article it is there, and what is the procedure to transfer a judge of High Court. Okay, so now remember, a judge of High Court is transferred under Article 222. So Article 222 of the Constitution deals with the transfer of a judge of High Court. Transfer of a judge of a High Court. Okay. So how the transfer is done? The answer is simple. The transfer is done by the President of India. President is responsible for transferring a judge from one High Court to the other. Now, there might be some confusion that whether it is done by the President or by the CGI or by the Governor. The answer is final. It is the President of India who transfers a judge from one High Court to another High Court. But obviously, the President is not going to do this on his own. I mean, the President does not have the authority that he can transfer a judge in his on his own terms and condition. No. So, how the transfer is done? See, the answer is simple. Let us assume that this is High Court A and this is High Court B, and there is a judge whose name is XYZ. We want to transfer this judge from High Court A to High Court B. So, who will do this? This will be done by the President of India. So, the transfer is done by the President, but obviously, the President cannot do anything on his own. There is no discretionary power with the President when it comes to the transfer. The President cannot transfer a High Court judge just like that. He needs consultation. So from whom he will take the consultation? The answer is, while transferring, the President has to consult the Chief Justice of India and 4 senior-most judges of Supreme Court. So this is the collegium of 5 Supreme Court judges. They will give consultation to the President, but the consultation is still not over. According to consultation procedure, the consultation is taken from 5 judge collegium, including, we also have to take the consultation from the Chief Justice of this High Court and the Chief Justice of this High Court. So when it comes to the consultation procedure, consultation is taken from the Chief Justice of both the High Courts and a collegium and Supreme Court 5 judge collegium. Okay. So this is the consultation procedure for the transfer of High Court judge. Okay. So this is important because it has been in news. Now, after the transfer, what else is in news is the removal of the judge of Supreme Court and High Court. Okay, so the removal, see, appointment is important and removal is important. But right now, removal is more important than the appointment. So now we will start with the removal of judge. Removal of judge. Now, you must remember that for removing a judge, we actually use the term removal and not impeachment. But even if you say that we are about to start the impeachment of the judge, then there is no issue, because in majority of the books available in the market, there the term impeachment is mentioned for the removal of judge. But according to Constitution, the impeachment is a procedure for the removal of president. Impeachment should not be understood just like a procedure for removal. No, impeachment is specific. Impeachment means the procedure to remove the president, not just anyone. Okay, so because if you think impeachment is just removal, then you will use impeachment for each and everyone. I mean, when it comes to the removal of Chief Election Commissioner, you will say impeachment of CEC. When it comes to the removal of CAG, you will again say impeachment of CAG. For judge, you will say impeachment of judge. But constitutionally, impeachment is only for the president, and for judge, we use removal. But even if you say impeachment of judge, then no issues, no one is going to be concerned about it. Okay, because that is technical. I mean, no one is concerned about these technicalities. So the removal of judge. Now remember, the removal of judge has been borrowed from the Constitution of USA. Okay. Second thing, the removal of judge, it is same for the Supreme Court and High Court. So the process which is adopted for the removal of a judge of Supreme Court, the same process is applicable to a judge of High Court. So the procedure for the removal is same for both Supreme Court and High Court. But this same procedure can be applied even to other functionaries. For example, CAG. CAG is the Comptroller and Auditor General of India. We all know that the function of the CAG is to audit the accounts of the center and state government. So the accounts of center and state both are done by the CAG. So the CAG is also removed in the same manner which is applicable for a judge of Supreme Court. Now the Chief Election Commissioner, he is also removed in the same manner. And one more, SEC means State Election Commissioner. So they all are removed in the same manner. So what we will study today, it will be for a judge of Supreme Court, how a judge of Supreme Court is removed. The same procedure will be applicable for all these, whether it's judge of High Court, CAG, Chief Election Commissioner, or State Election Commissioner. Okay, so now we know that the process is same for all. One more thing, when it comes to the removal, we should also remember what is the charge against a judge. I mean, on what ground we can remove a judge from the court. So there are only two charges. The first charge is misbehavior. The first charge is misbehavior, and the second charge is incapacity. Now, when I say incapacity, incapacity basically means either you are mentally incapable or physically incapable. So, incapacity means mental or physical incapacity, whereas misbehavior is a broad term. You can include corruption, okay, within its ambit. So, misbehavior includes the corruption and all, and incapacity means physical or mental incapacity. So, there are only two grounds on which a judge of Supreme Court or High Court can be removed, and these are those two grounds. There is no scope for any other ground. Okay. Now, after all this, let us start how a judge is removed. See, the answer is simple. A judge of Supreme Court or of High Court is removed by an order of the President. So, who is responsible for removing a judge from the office? It is the President of India. The President by order can remove a judge from the office. But we all know the President is not going to pass an order just like that. The President needs some advice, consultation. Now, don't think that the Council of Ministers is going to give consultation to the to the President of India that you remove this particular judge. No, that's not going to happen. And again, there is no role of collegium in removing a judge. Collegium is not going to recommend to the President that you remove this particular judge. So, when it comes to the removal, there is no role of the Council of Ministers and there is no role of the collegium. The role of collegium is in the appointment procedure and in the transfer of judges, but not in the removal of judge. Okay, so who is responsible? It is the Parliament of India. The Parliament will tell to this President, the Parliament will tell that you remove the judge from the High Court or Supreme Court. So it is the Parliament who is going to give direction to the President that now you should remove this particular judge. But how Parliament will initiate the procedure? Okay, so remember, according to Constitution, if both the Houses of Parliament passes a resolution by special majority, then the President has to pass an order for the removal of judge. So, in order to remove a judge, the resolution from both the House of Parliament must be passed by special majority. And when I say both the House of Parliament, it means that even if one of the House rejects the resolution, then the President is not going to pass the order. In order to pass the order, the resolution should be passed from both the Houses of Parliament. Okay, so let us start that how this procedure will begin from either house. Now, we all know in Parliament there are two houses. The first is Lok Sabha and the second is Rajya Sabha. Now remember, we all know that out of these two, Lok Sabha is more powerful. But when it comes to the removal of the judge of Supreme Court or High Court, they both are equal. I mean, they both enjoys equal power when it comes to the removal of Supreme Court or High Court judge. So equal means the process can be starting from the process can be started from either house, and the process will be completed only when both the house will give their approval. Even if the one house rejects the resolution, then the President is not going to pass the order. So I can start the procedure from either of the house. So let me first start the procedure from Lok Sabha. Now in Lok Sabha there are total 543 members. To start the procedure we require at least 100 members. Now these 100 members will say that this particular judge is guilty of misbehavior or incapacity. So according to these 100 members, at least 100 members are required. So these 100 members will say that this particular judge is guilty of incapacity. Now they will submit this to the head of the Lok Sabha. The head of the Lok Sabha is the speaker. So these so in Lok Sabha, at least 100 members are required to initiate the procedure. Once the 100 members are there, then they will submit to the speaker. Now it is up to the speaker whether he wants to accept or not. So suppose they said that the judge is guilty of this, but the speaker said no. Then the process will end. But what happens if the speaker says yes? The speaker says yes, okay, you are correct. Then what will happen? Then for deeper investigation, we require a committee. A committee will be constituted by the Speaker of Lok Sabha for deeper investigation. So what is the function of the committee? The function of the committee is to investigate the charge. Now, how many members are there? 3 members are there. We have to remember the name of all these 3 members. The first member is the Chief Justice of India. But what if he is being removed or he is not at present or there is conflict of interest? Then they will be a judge of Supreme Court. So the first person is from the Supreme Court. The second is Chief Justice of any High Court. We have 25 High Courts. Chief Justice of any High Court. So the second is Chief Justice of a High Court. Chief Justice of High Court. The third is Distinguished Jurist. Distinguished Jurist in the opinion of the Speaker. When it comes to the qualification, it is in the opinion of the President. See, in qualification, you will find that the C point says that it should be a distinguished jurist in the opinion of the President. But here it is not in the opinion of the President, it is in the opinion of the Speaker. I mean, whosoever is constituting. If the Speaker is constituting the committee, then it is the Speaker opinion. If it is Chairman, then it is the Chairman's opinion. So, the task of this committee is to investigate the charge, and after investigating the charges, the committee will submit its report. Now, the report will be submitted in both the House of Parliament. If in the report it is said that no, the charges are false, then the process will end. So, once the committee says that the charges are false, then the judge will be, then the process will end. But what happens if the committee in its report says yes, the charges are correct? Then after yes, the Lok Sabha will resume the procedure. Now the Lok Sabha will introduce a resolution for the removal of the judge. Now this resolution should be passed by special majority. Now remember, it is important that this resolution is passed by special majority. Suppose the committee said, okay, the judge is guilty of corruption. Okay, but what happens if there is no resolution? I mean, the resolution is not passed by special majority. Then remember, the process ends. So, it is important that the resolution is passed by special majority from the House. And once the resolution is passed from this House, then it goes to the other House. Now, what is the function of the other House? The function of the other House is to pass the resolution by special majority. Now, there is no need to constitute the committee, because only once this committee is constituted, from whichever House this process is initiated, that particular House will constitute the committee. Okay. So the task of the other House is to pass the resolution by special majority. And remember, suppose Lok Sabha passed the resolution by special majority, but Rajya Sabha failed to pass the resolution by special majority, then the President will not pass the order for the removal of judge. In order to remove a judge, this resolution should be passed from both the Houses of Parliament and not just by one House of the Parliament. So this is the procedure for the removal of a judge. But right now we have seen that how the process will start from Lok Sabha. But what about Rajya Sabha? The process can be initiated from Rajya Sabha. So if we have to start the procedure from Rajya Sabha, so there are 245 members in Rajya Sabha. If we have to start the procedure, then at least 50 members are required. Now these 50 members will submit to the head of the Rajya Sabha, and he is the chairman. Now again, same option. It is up to the chairman whether he wants to accept or reject. If the chairman said no, I do not accept all these charges, then the process ends. But if the chairman accepts, then this time the chairman of the Rajya Sabha will constitute the committee. So it all depends from where the procedure has been initiated. If the procedure has been initiated from the Lok Sabha, then the Speaker of Lok Sabha is going to constitute the committee. But if the procedure has been started from the Rajya Sabha, then obviously the chairman of Rajya Sabha is going to constitute the committee. So it all depends that from where the process has started. Now the function of the committee is same and the composition is also same. It doesn't matter whether the Speaker is appointed or the chairman is appointed. The composition of the committee will remain same. That is, the first is CGI or Judge of Supreme Court, second is Chief Justice of any High Court, and the third is the Distinguished Jurist. Now, we all know the task of this committee to investigate the charge. And now the same process. Now the report will be tabled in both the Houses of Parliament. If the committee said no, the charges are false, then the process ends. But if the committee gives the green flag, then the Rajya Sabha will introduce a resolution for the removal, and the judge will be removed. I mean, the resolution will be passed by special majority. And once the resolution is passed by special majority, then it goes to the other house. And now the task of the other house is to pass the resolution by special majority. Only when the other house passes the resolution by special majority, then we can finally say that the President is going to pass the order for removal of judge. Remember, the President is bound to pass the order for the removal of judge if both the Houses of Parliament have passed the resolution by a special majority. Then it is compulsory for the President to give his to pass the order for the removal. So this was the process for the removal of a Supreme Court judge, High Court judge, CAX, Chief Election Commissioner or State Election Commissioner, because all the points are same for all the constitutional functionaries. Okay, now apart from this, the removal process, we should also understand that whether this has ever happened in the history of independent India that a judge has been removed from the office. No, so far no judge has been removed from the office, whether it's Supreme Court judge or High Court judge, no one. Okay, but this process has been initiated 4 times. Okay, so for whom this process was initiated? It was initiated for V. Ramaswamy. So V. Ramaswamy is the first case in the Indian history where you will find a process has been initiated for his removal. So V. Ramaswamy is judge of Supreme Court, was a judge, sorry, V. Ramaswamy was judge of Supreme Court. Okay, but the process was started from Lok Sabha, and the committee found the judge guilty of the misbehavior. But what happened that the resolution was not passed by special majority because Congress abstained from voting. 273 votes were required, but only 196 votes were cast. I mean, it only got the support of 196 votes out of 273. So the resolution was defeated in the Lok Sabha. Now, this was the first case against whom the process was initiated. The second case is of P.D. Dinakaran. P.D. Dinakaran. P.D. Dinakaran was the judge of Sikkim High Court. Okay. He resigned in between the procedure. The third was Soumitra Sen, judge of Calcutta High Court. The fourth was Deepak Misra, CGI. Remember, for Deepak Misra, what happened? The process was initiated from Rajya Sabha, but when it was submitted to the chairman of Rajya Sabha, the Rajya Sabha chairman rejected. So the process ended when the chairman of Rajya Sabha disapproved. Okay, they both resigned in between. His resolution was not passed by special majority, and in this case the chairman said no. Okay, so that's why so far no judge of Supreme Court or High Court has been removed. And there is one more thing, that is called in-house procedure. I will also discuss what is in-house procedure, but before this, let me tell you about the Judges Inquiry Act. Okay, remember there is an act called Judges Inquiry Act, passed in 1968. Now, the Judges Inquiry Act of 1968, this particular act says that how the procedure will be initiated from either house of the parliament. It is according to this act that 100 members are required at least in the Lok Sabha or 50 members in the Rajya Sabha. A committee will be constituted consisting of these 3 members. Okay, so all these things are mentioned in the Judges Inquiry Act of 1968. So what is there in the Constitution? In Constitution, it was mentioned under Article 124 Clause 4, it was mentioned that a judge will be removed from the office by an order of the President. But for this order, the Parliament must give approval, and the Parliament will give approval only when the resolution is passed from both the houses of Parliament by special majority. So only this much was mentioned in the Constitution under Article 124 Clause 4, that a resolution will be passed from both the houses of Parliament by special majority, and then only the President will pass the order for the removal of judge. Apart from this, there was no mention about the how the process will be initiated from either house. So what we have studied, that 50 members are required from Rajya Sabha, 100 members from Lok Sabha. This was not mentioned in the Constitution. It was mentioned in the Judges Inquiry Act of 1968. Then it will be submitted to the Speaker or Chairman. They will have the discretion whether to say yes or no. Then a 3-member committee will be constituted. How many members will be there? I mean, who will be the first member, second or third? And then how the committee will function. What happens if the charge is incapacity? Then a medical board will be constituted in order to assess whether he is mentally or physically incapable. Then all these things were mentioned not in the Constitution but in the Judges Inquiry Act of 1968. Okay, and this particular act was passed under Article 124 Clause 5, because under Article 124 Clause 5, the Constitution said that it is up to the Parliament to determine the procedure. Okay, so finally we are done with the removal of a judge of Supreme Court or High Court. Now, what about the in-house inquiry? See, again, in-house inquiry has been initiated by the Chief Justice of India, Sanjeev Khanna, against the Yashwant Verma, judge of Delhi High Court, who is about to be transferred to Allahabad High Court. So the process has been initiated against him. Now, what is in-house inquiry? What is in-house inquiry which has been initiated against which has been initiated against Delhi High Court Judge Yashwant Verma? So remember, this in-house inquiry was introduced by Supreme Court in 1999. So Supreme Court adopted or introduced the in-house procedure in 1999. Actually, what happened in 1995? There was a case, Ravi Chandran Iyer case. In that case, it was in 1995. So in that case, Supreme Court felt for the first time that there should be a procedure other than impeachment, where sometimes the charges are not that grave, for which there should be a proper removal procedure for a judge. Okay, so what they felt that sometimes the charges are not that serious, and moreover, the procedure to remove a judge is rigid. I mean, it is tough to remove a judge. So there should be some other mechanism by which we can remove a judge from the office without invoking this procedure that is under Judges Inquiry Act of 1968. So Supreme Court felt for the first time that there should be another mechanism to remove a judge. Okay, and that mechanism should be flexible, easier than the present mechanism which we have studied right now. So this need was felt in Ravi Chandran Iyer case in 1995. Then a committee was constituted, a 5-member committee was constituted in 1997, and in 1999, finally the Supreme Court adopted the in-house inquiry procedure. And remember, in 2014, the Supreme Court gave the detailed guidelines about the in-house inquiry procedure. Okay, so in the in-house inquiry procedure, a complaint can be made either to the CGI, President, or the Chief Justice of the concerned state High Court. And now, after the complaint, the matter goes to the Chief Justice of India. Now it is up to the Chief Justice of India whether he want to accept or want to reject. Suppose the charges are frivolous, okay, these are minor, then the CGI can reject the charges. But if the charges are grave in nature, then the CGI of India, I mean the CGI, will ask the Chief Justice of the High Court to conduct a preliminary investigation. And after preliminary investigation, if the Chief Justice of India is satisfied that yes, it requires deeper investigation. So after preliminary investigation, the CGI will appoint a committee for deeper investigation. Now, the composition of this committee varies depending upon the complaint. If the complaint is made against a judge of High Court, then the 3-member committee will be different. If a complaint is made against a Chief Justice, then the composition of the committee will be different. And if the complaint is against a judge of Supreme Court, then again the committee is going to have different members. So for deeper investigation, a committee is constituted by the Chief Justice of India, and once this committee concludes the report, if according to the committee the charges are minor, then the CGI can warn that judge, okay, that this should not happen again. But if the charges are serious, then the CGI will ask the particular judge to resign from the office. But what happens if the judge says, no, I am not going to resign from the office? Then the CGI will recommend the removal to the President and Prime Minister. Then accordingly, the Parliament will initiate the procedure for the removal of judge. So remember, under in-house inquiry procedure, the complaint can be made either to the Chief Justice of India, Chief Justice of the concerned state High Court, or to the President. And ultimately, it is the CGI who is going to appoint the committee for the deeper investigation of the charge. And the composition of the committee depends upon the fact that against whom the complaint has been made, whether it is a judge of High Court, Chief Justice of Chief Justice of High Court, or a judge of Supreme Court. So let me write the composition of the committee. Okay, and remember, I'm just going to remind all this, that if according to the committee the charges are grave, then the CGI will ask the judge to resign. If he refuses to resign, then the CGI is going to recommend to the Parliament that you remove this person from the office. Okay. Now, what is the composition of the committee? Now, see, suppose a complaint has been made against a judge of High Court, hai na? So, if the complaint is against a judge of High Court, then the committee which will be formed by the Chief Justice of India for investigation, that committee will obviously consist of 3 members. Now, these 3 members will be 2 Chief Justice of a High Court, I mean of any High Court. So, Chief Justice of 2 different High Court will be the first 2 members, and the third member will be Judge of High Court. Let me write it again. 2 Chief Justice, okay, and 1 will be Judge of High Court. Judge of High Court. Remember, 2 Chief Justice obviously of different High Court, not of the same High Court, because in one High Court there will be only 1 Chief Justice. So, 2 Chief Justice of different High Court and 1 High Court Judge. Okay, this is for when the complaint is against a Judge of High Court. Now, what about when the complaint is against Chief Justice of High Court? So, when the complaint is against the Chief Justice of High Court, then the committee constituted will obviously consist of 3 members, but this time the composition, I mean the members vary. I mean there will be 2 Chief Justice of different High Court, but this time the third member will be a Judge of Supreme Court. Judge of the Supreme Court will be the third member. Here it was the Judge of High Court, here it will be the Judge of Supreme Court. Now third, if the complaint is against a Judge of Supreme Court, then what will happen? If the complaint is against a Judge of Supreme Court, then in this case, the committee constituted will consist of 3 Judges of Supreme Court. This time there will be no scope for Chief Justice of High Court. It will be 3 Judges of the Supreme Court as the member of the committee. And once the committee finds that the charges are true and these are grave in nature, then obviously they will ask the judge to resign. See, now we have found another procedure where a judge can be removed from the office even without invoking that procedure, which is a rigid procedure and a tough procedure. Okay, because so far no judge has been removed, so we can understand that that procedure was tough. Okay, so this was another way to remove a judge from the office, not to remove but ask him to resign from the office. Okay, so with this we are done with the removal of judge, transfer of judge, and the in-house inquiry, which was introduced in 1999. Okay, so we'll meet in the next class. Okay, so thank you everyone.